Part 7, Year 2024. The Courtroom Showdown. This was the moment that would demand everything Latonia had. Not just evidence, not just strategy, but endurance, courage, and the strength to stand up and fight for herself in court. Latonia says the museum's attorney learned she was preparing to file a motion for summary judgment. She alleges they rushed to file their motion first in January and pushed to get it heard before hers, so her motion might never be considered if they won first. Latonia hired a limited appearance attorney to make sure both summary judgment motions were heard together. At the hearing, the museum's attorney argued Latonia had delayed the case and pushed to have their motion heard first that day. Latonia says the other party's attorneys joined in, insisting they needed to be heard immediately. The judge said no, both motions would be heard together. It was finally court day, in person, just as the judge required. Now it was Latonia's turn to speak, alone. No lawyer beside her, just Latonia, the judge, and 4 attorneys across the room. But she pulled herself together, found the courage, and stood up to face them all. The museum argued Latonia's inter vivos gift was a contract, and that her claim was time-barred because she didn't take possession within 2 years. The judge rejected that. It was not a contract, so the museum pivoted, arguing their document was the separate writing referenced by the will. Latonia argued the art was a completed gift, supported by a signed letter from the decedent, his sister's affidavit, a sworn witness statement from the day it was signed, and a document examiner's certificate confirming the signature. She also argued the museum was relying on a document with a notary stamp the notary later said he never notarized and had never seen, and she asked the court to strike it under the best evidence rule. The sister's attorney argued the art was bought with business funds, so she claimed it was business property and said the sister should receive most of it. She also attacked the museum's document over the same issues Latonia raised: notary problems, no original, and reliance on an older will. Latonia argued the business had already closed, so the artwork was personal property when Alexander gave it to her. The judge agreed. Stay tuned for Part 8, the continuation of the March 2024 court hearing, and this is where things turn ugly.